Are alternative dispute resolution methods available in IP litigation? In recent news, the legal community is buzzing about alternative dispute resolution methods in intellectual property litigation. As businesses face increasing trademark and patent disputes, many are searching for faster and less costly ways to resolve conflicts. This trend is particularly relevant as traditional court litigation can be time-consuming and expensive. So, what options are available? Yes, alternative dispute resolution methods are indeed available and gaining popularity in intellectual property litigation. These methods provide alternatives to the conventional courtroom setting, allowing parties to settle disputes more efficiently. One common method is arbitration. Here, a neutral third party makes a binding decision on the dispute. Arbitration can be quicker than court proceedings and offers flexibility, although it may still incur significant costs. Many choose arbitration for its enforceability and confidentiality, making it a preferred option for sensitive intellectual property matters. Another widely used method is mediation. In this process, a neutral mediator helps facilitate negotiations between the parties. Unlike arbitration, mediation does not result in a binding decision. However, it can help preserve business relationships and reduce both time and expenses involved in resolving disputes. Additionally, expert determination is an option where an expert in the relevant field is appointed to decide specific technical issues within the dispute. This method is particularly useful in complex intellectual property cases where technical knowledge is essential. Specialized forums for alternative dispute resolution exist, especially for technology and intellectual property matters. For instance, the World Intellectual Property Organization Arbitration and Mediation Center offers tailored services for intellectual property disputes. Recently, new bodies like the International Games and Esports Tribunal have emerged to address disputes in the growing esports sector, reflecting the evolving landscape of intellectual property issues. The advantages of alternative dispute resolution in intellectual property litigation include confidentiality, speed, and the ability to select decision-makers with relevant technical expertise. However, it is important to note that mediation requires cooperation from both parties and does not guarantee a binding outcome. On the other hand, while arbitration is binding, it can still be costly and less transparent than traditional court proceedings. In the realm of trademark enforcement and patent disputes, incorporating alternative dispute resolution methods into legal strategies is becoming increasingly common. This approach helps manage costs and resolves disputes effectively without the need for prolonged litigation. Overall, alternative dispute resolution methods are valuable tools in intellectual property litigation, providing alternatives that better suit the specific needs of the parties involved.